Florida is now in session. The Honorable Scott Maycar, Judge presiding. All persons having business before this court draw near, give attention, you will be heard. May God save the United States of America, the state of Florida, this honorable court. Please be seated.
Well, good morning, everyone, and welcome to the 5th District Court of Appeal. Today is the Complex Commercial Case Day. We've got two cases on our docket, and we will start with case 24-1156, Deltona Transformer Corporation. With me today are Judge Soud and Judge Boatwright. Let's pronounce those names correctly, right, Judge Soud? Had some very interesting mispronunciations the last couple of years. So we have, I believe, 20 minutes per side, and the appellant, of course. I guess we have a, let's see, is there a cross appeal on this one? No, that's the second case, okay. So if the appellant would just let me know what time you want to reserve, we will do so. Counsel, you're prepared to proceed? All right, please do so.
Good morning, and may it please the court. My name is Tara Price of Schutz & Bowen on behalf of Appellant Deltona Transfer Corporation, or DTC. I'd like to reserve 5 minutes for rebuttal, please. This is an appeal where the trial court failed to follow Florida law in the face of contentious litigation among family members. In this case, a father who ran a successful corporation subsequently gave shares to his daughter, sons, and 2 nephews. Only a few years after that, this suit and many others followed, alleging that the son and nephews wrongfully ousted the father and daughter so that the son and nephews could take total control. Today, I would like to discuss 3 of the trial court's 5 errors that we've provided in our briefs. First, the trial court erred when it ruled it lacked the authority under Section 607.1436, subsection 1, Florida statutes, to set aside or modify Deltran's notice of election based on the equities. Second, the trial court erroneously ruled that it was forced to choose between 2 expert witnesses' opinions that it concluded were wrong. And third, the trial court entered the valuation judgment and ordered payment without complying with Section 607.1436, subsections 5 and 8. Because the trial court failed to follow Florida law and entered a valuation for the Class B share based on the wrong legal standard, this court should reverse the valuation judgment and remand for additional proceedings in compliance with Florida law. With regard to the first issue, the trial court erred when it ruled that it lacked the legal authority to even consider whether it could set aside Deltran's notice of election based on the equities.
So I agree. I tend to agree with you that the irrevocable language is followed by unless. So I tend to agree with you that that seems to at least provide a limitation that this could be set aside. But how do you answer the appellees, at least their response to part of this, when you read subsection 2, which seems to be, to me, to be the procedure and how this would follow? And in the last part of subsection 2, it seems to exclude, it says other than the petitioner, seems to exclude the petitioner from being able to, at least the appellee argues, from setting aside the election. The setting aside would only be for the corporation or the shareholders, it appears, that are making the election.
Yes, Judge Boatwright, I'd be happy to explain. The appellee's argument is based upon subsection 1 being nested within subsection 2. But in fact, these are different subsections. Subsection 2 applies that particular sentence when the petitioning shareholder wants to either dismiss the underlying dissolution proceedings or wants to somehow settle the action or wants to subsequently sell their shares to some other entity besides the corporation. And so when that happens, the statute directs that the trial court is supposed to consider the equities with regard to the electing corporation and shareholders. We don't see that language in subsection 1. And as the New Hampshire Supreme Court ruled in the Bendenson case, The word in Section 1, irrevocable, displays an intent to bind both parties. Both the electing corporation or electing shareholders and the petitioning shareholders are bound. And so it also looked at the Model Business Corporation Act, Section 14.34, comment.
Was this statute based off of the Model Business Act?
It is my understanding, Your Honor, that Florida is a Model Business Corporation Act state, yes. And that comment, too, talks about how the purpose of this statute is so that there isn't any type of gamesmanship or there isn't any type of strategic advantage that's being used, both when the petitioning shareholder tries to dissolve a corporation and when the electing corporation or the shareholders file a notice of election. And if we only had it working in one way, you wouldn't have that protection for the petitioning shareholders. I'd like to note that the Florida legislature has been, in recent years, very concerned with the equities with regard to petitioning shareholders. In 2019, we saw an amendment to this statute in subsection 7, which previously used to allow a corporation that elected, or that filed a notice of election to wait until after the valuation proceedings were finished, decide whether it liked the value that was given to the shares, and then it could unilaterally decide.
What's the effect on your client if Deltran is dissolved versus the shares being purchased? What's the difference there?
Your Honor, the difference would be that DTC would. There are certain rights that Deltran is exercising that belong to DTC, for example, like a worldwide license agreement. That's part of a separate suit. But certainly if Deltran no longer exists, then DTC would have those rights back.
I believe the daughter, she had her shares purchased and she decided not to appeal the issue, correct?
Yes, Your Honor. I do not represent Ms. Dion. I'm here on behalf of DTC.
So there is a difference between, in your mind, dissolving this versus the shares just being purchased.
Absolutely.
There would be a difference to your client.
Oh, absolutely, Your Honor, absolutely. And, this Class B share that DTC owns, it's significant. I mean, if you look at the Articles of Incorporation, it's not like your typical share. It exists. It doesn't have a vote on every single issue, but
it has veto prerogatives in some instances.
Yes, Judge Stout, absolutely. And over very important issues. There are 5 of them, including the disbursement of dividends, including equity acquisition of another corporation, including debts over a certain size. And if you were to look at, I believe it's appendix page 74, you'll see Deltran's answer and counterclaims where it admits that the Class B share was created to protect DTC's to make sure it could continue to get payments under the various notes that it had with Deltran. And so this is a very important share that, as it existed, had an incredible value to DTC beyond just some market value.
If we agree with you on the first issue, about the statutory interpretation issue, and we remand it, what happens? And also, secondarily, what about the other issues? Or how are they affected? In other words, if we agree with you on the statutory interpretation, the trial judge misunderstood the statute, said, I can't go there, I can't do equity, and we send it back, what is that going to look like, and how does that affect the rest of your case on appeal?
Yes, Judge Makar. Although we would agree that there are numerous reasons to reverse and numerous instructions that should be given to the trial court. If the trial court were to reverse on this particular issue, if this court were to reverse on this particular issue, the trial court would need to hold a hearing where it actually allowed DTC to even make a case to present the equities. That would be with regard to the Class B share, because as Your Honor recognized, Ms. Dion has not appealed. And so if the trial court were to examine the evidence and then determine that the equities required that to be set aside with regard to the Class B share, then we would have, if that was appealed, something before this court as far as whether...
Well, to follow up on Judge Makar's question, wouldn't that reset everything? Because if you set aside the election, then now you'd be pursuing dissolving not dealing with purchasing shares at this point. Is that, I mean,
I see, I understand. My apologies. Yes, I think that's right, but this is what should have happened in the
so that
first-
would, following up on Judge Makar's, I think what he's, and I don't want to put words on what he's asking, but it would reset, I mean, we would be, you'd be dealing with whether this, at that point, looking at whether this should be dissolved, not dealing with these other issues. Is that correct?
We would be looking at to whether it's equitable for the trial court to set aside or modify the notice of election.
And if they did that, then it would be
We would be back to
proceeding on a
dissolution.
dissolution proceeding, not dealing with purchasing the shares or in that instance, correct?
That's correct, Your Honor, but
Okay.
it's not just because this court reverses, there's going to be a dissolution of the corporation. There's still many, many steps before we get to that point, if the trial court were to get us to that point.
Is there any argument, I don't recall whether I believe made, that it's harmless?
I
I mean,
didn't,
that equity was done in the judge's mind, and that sending it back to have this hearing to say, well, is it equitable or not? Well, hey, I've already kind of done what I thought was the right thing to do.
Your Honor, I don't believe that issue was raised on appeal. However, even if this court were to consider it, I think the legislature, I think the error has to be harmful because the legislature has directed the trial court that it can consider whether to set aside or modify based on the equities. And so prohibiting DTC from even being able to make a case, not even getting a ruling as to whether
Well, that'd be like a due process argument. You've been denied your due process right to make your case.
it would be harmful.
But what would you present in this hearing on remand that you haven't already presented in the main case?
Your Honor, there in our appendix, there was a motion to set aside, and I believe that raised a number of issues beyond just what was in the complaint, and so certainly those issues would be argued. And then, of course, the parties went back and forth on the supplemental memos with regard to the legal issues. But the trial court never actually made that determination, never actually made that consideration. So this is a denial of an opportunity that the legislature has determined rightfully belongs to the trial court to ensure that these types of proceedings are fair. These are all equitably based. Corporate dissolution is based in equity. Valuation of shares is based in equity. Whether to set aside a notice of election is based in equity. And to agree with Appley's argument is to kind of rob the trial court from having the ability to look at the equity, even if there were a situation where an electing shareholder were going to have an unfair advantage.
In regard to the value of the Class B shock, I mean, there's the stock, there's quite a big difference between the two experts, correct?
Yes, Your Honor.
Okay, so what other evidence was available to choose a different value? I mean, it's kind of left the trial court in a position to choose one or the other. Was there other evidence available where the trial court could have come to a position? It seemed like the trial court wanted to come to a position more in the middle and did not.
Yes, Your Honor. The trial court certainly made a number of statements during the valuation hearing, and the valuation and judgment itself evinces that.
But isn't that on the parties to provide, I mean, different alternatives? I mean, you kind of provided one, they provided one, the judge chose one of the two. Why is that not within the trial court's discretion to do that at that point?
Your Honor, I believe it is within the trial court's discretion, if I'm understanding your question, to be able to look at the evidence in its entirety and to be able to take, I think what happened is the trial court was focused on, I have an opinion that it's this 567,000 number, and I have an opinion that it's this 3,380 number. And I've got to pick one or the other, and I don't like what underlies either of them. And so, I mean, the trial court even asked in the underlying proceedings, if I reject one, don't I have to accept the other? But what this court has previously ruled in the Ramphel case and the Lally
But she was,
case,
the trial court judge was informed that it did not need to do that, correct?
yes, Your Honor,
Okay.
DTC trial counsel did inform the trial court that did not need to be done, that she could have looked at the different methodologies, she could have fashioned her own number, she could have looked at evidence such as Judge Stroud's comment about having a veto vote, how many different votes are there. There are a number of things. But at the end of the day, if there wasn't enough evidence, the Ramphel case also shows that the trial court could have asked the parties to go back and submit more evidence. Simply because there isn't enough evidence in the proceedings doesn't mean that it's okay to enter in a wrong valuation.
Was that asked?
I don't know whether that was asked, Your Honor.
Okay.
Are there still other pending lawsuits dealing with this issue?
Yes, Your Honor.
As I read in the briefs, are there five, or in the record, are there 5 pending lawsuits?
There are, I'm not trial counsel, so I don't want to misspeak. I understand that one may have been settled. I understand that another was ruled recently in DTC's favor on summary judgment, and there are other suits that are heading for trial. It was supposed to happen this past fall and has been continued.
Any of those suits would affect any of the issues here in this appeal?
Only to the extent if the trial court is looking at, well, I guess, I'm sorry, can you rephrase so I make sure I understand your question, Judge Butler?
Yeah, I saw where there were 5 pending lawsuits dealing with all these issues. I wondered if that would have any bearing on this appeal. That was the only
I don't know that the issues in those lawsuits necessarily would decide issues in this lawsuit or vice versa, but there may be decisions made in other lawsuits that show either mismanagement or bad judgment or you know what I mean, decisions like that. That certainly could be evidence that could be used in this case, certainly. I see that I'm getting close on my rebuttal time. I do want to briefly just state that the trial court's valuation judgment was not made in compliance with subsection 5 or subsection 8. Appellees have no argument with regard to subsection 8 other than its harmless error. And I believe the court should disregard that because it's not based on any evidence that the trial court had in front of it and is insufficient in its own right. And I believe that subsection 5 speaks for itself when it requires the trial court to enter an order that includes decisions as to whether there's an entitlement to awards and fees or as to whether the petitioning shareholder had a right to bring the petition for dissolution in the first place. These are significant errors that have a real impact. And we're talking about statutory procedures where a corporation comes to a court to ask for assistance to take a shareholder's property that they're unwilling to sell. And so we have to be able to allow the trial courts to evaluate the equities in these types of situations. The legislature would certainly want the trial court to follow the Florida statutes as they're written. And because that was not done, DTC requests that you reverse the valuation judgment and the erroneous rulings with instructions on remand for further proceedings.
Thank you, counsel.
Thank you, Your Honors.
If it may please the court, my name is Halla Sandridge, and I represent the appellees who I will refer to collectively as Deltran. I would like to start first with a response to the issues related to the construction of subsection 1 in 607-1436. The only way that DTC gets to where it is by ignoring the words of the statute itself. We filed supplemental authority, the Lumpus case out of the Florida Supreme Court, and it would require this court to use and apply the common understanding of the word election and irrevocable and give them their plain meaning.
Well, the statute does say irrevocable, but then it says unless. It places a limit on the irrevocable nature of that, doesn't it?
Yes, and let me go through exactly what you just said, Your Honor, and explain to you why the exact language of the statute supports our argument that the only party that can seek to revoke the election is the party making the election. So let's take a look at subsection 1, and it says, an election pursuant to this section shall be irrevocable. It doesn't stop there. It says, unless the court determines that it is equitable to set aside or modify the election. So an election pursuant to this section shall be irrevocable. We know who makes the election. Only the shareholder or the corporation make the election. Then it says it shall be irrevocable. Under any common understanding of that phrase.
What would be the rationale? Why the rationale for not allowing the petitioner petitioning for dissolution and just the party moving for the election to be able to have it set aside for equities? What would be the rationale in that?
The rationale is that the Florida legislator, and we'll get to the commentary in a moment, wanted to end the litigation, wanted to be able to allow corporations to proceed if minority shareholders were unhappy and could be bought out. Imagine, Your Honor, a 1% minority shareholder. They would have the right to file to dissolve. And if the majority shareholders running the corporation successfully could not buy out that minority shareholder, Florida corporate law would come to a screeching halt. And so our legislator wanted the the electing shareholders to be able to come in, make the election, and go forward with it.
But that could be considered as part of the equities broadly, could it not?
I don't believe we get to that issue because of the way this sentence is structured. And just so you know, and this is very interesting to me, the Bendenson case on which they rely, which was rejected by the Utah case, the Hills versus Nelson case from the Utah Supreme Court. Here's what it does, and I think this violates Florida Supreme Court principles. In Bendenson, the court admits, we agree with the respondents to the extent that the term irrevocable commonly describes the relationship between an actor and an action initiated by that actor. Thus, generally speaking, if an action is irrevocable, the actor who initiated the action may not withdraw it, alter it, or otherwise call it back. You would think with that determination that would end the story because of how irrevocable is commonly understood, and that's what our Florida Supreme Court asks us to do. But then the New Hampshire court goes on to look at commentaries to find that it will not use what it has described as the commonly accepted meaning. So we believe, and even the New Hampshire Supreme Court agreed with this, that when you are looking at this language, it is referring just to the party who is making the election. And then the language, unless, is the limiting language on the party making the election. And it makes sense that there might be a scenario where the party making the election would need to have the court adjust it, modify it, or set it aside. There could be a death. There could be something that happened in the corporation to value the shares so high that they could no longer afford to purchase them. So there could be equitable reasons in which the election should be set aside.
Does the language in subsection 2 or section 2 support the reading of section 1?
It does. We are not saying it is subsumed within section 1. We are saying that they are separate sections, and they each define a separate scenario. The first scenario in subsection 1 is all about our election and whether we can revoke it. Subsection 2 deals with scenarios where the petitioner may come in and ask for different relief. And it gives very specific situations in which they can do that. So
you agree with the appellant on that they are two different provisions?
They are two different provisions dealing with two different situations. The first one, again, is the ability of the electing petitioners whose election is otherwise irrevocable unless the court determines that it is equitable to set it aside. So what would happen is that if we made the election, we would have to go to the court in order to revoke it. And the legislator set a standard. The standard is it has to be equitable. And it's interesting to me that... How do you read subsection 2? What do you say subsection, what do you read subsection 2 as? So subsection...
You said you see a differentiation between the two.
So what subsection 2 does is it talks about after an election is filed, it talks about very specific scenarios in which there can be a scenario of settlement, of discontinuation by the petitioner, of its action, all things that might affect the election. It's a completely different scenario. And what it does is it sets forth the rights of the parties under those specific scenarios: discontinuation, settlement, and sale. In those situations, the court says it also can be set aside, but what we're going to look at is whether or not it is fair and equitable to the electing parties. And here's why that language does not need to be in subsection 1. Because of what I've just said. Because subsection 1 already has it built in. Obviously, we are the electing shareholder or corporation coming to the court and asking for it to be set aside. The court doesn't have to determine whether it's equitable for us because we're the ones asking. So the fact that that language is not in there is totally consistent with the way we have construed it to the court. So let me go back to one of the cases that I think is important here, and that is the Hill versus Nelson case, 2022, out of the Utah Supreme Court, and it addressed Bendenson, and it rejected Bendenson, and it looked at its own commentaries, and it said exactly what I'm saying to you, Your Honor, that it should be construed in the manner that allows only the electing shareholder or corporation to revoke its election. And if we don't believe that this court needs to go any further than the plain language of subsection 1 and subsection 2, but if the court needs to, the commentary to the Model Business Act in Florida says that the right of the electing shareholder or corporation is absolute, and that the reason for that is so that they can control ending the litigation. Judge Boatwright, you asked why. What would be the policy reason? Again, it goes to ensuring that if a motion or a petition to dissolve a corporation is filed and causes havoc in the operation of this corporation, Florida has an interest, the legislator has an interest in its commercial companies proceeding and having a healthy commercial environment. And what it has done is it has allowed the majority shareholders to not be held hostage by let's again say a 1%, and that's what we have here. DTC has 1 share, and it is now holding us hostage. And allow...
It's a different class.
It is
It has a Class B share.
He has a...
It doesn't have 1 share of 100 other shares. It has 1 of 1.
It has one
That
of
would certainly be relevant to the analysis, would it not?
I wouldn't disagree with you that if we ever got to that point, it might be relevant to the analysis. But again, we don't get to that point because the statute doesn't give DTC the opportunity to come in and revoke the election. And that is what the appellants do in this case. They ignore the language election and section, and the way they say it reads in their reply brief, they say the answer brief dances around the plain language of subsection 1, which authorizes the trial court to set aside or modify the election if the court determines that it is equitable to do so. That is not what the statute says. The statute is very clear on its face that it says unless the court determines that it is equitable. If, for instance, it said an election pursuant to this section shall be irrevocable, period, and it didn't have the limiting language following unless, then maybe their argument could carry some muster. But it doesn't here when it has this limiting language. And so we believe that their statutory construction argument is flawed under Florida law. It should be given its plain meaning. And if we have to look at the commentaries, the only Florida commentary supports our reading of this specific statute. Judge Makar, I wanted to address a question that you had asked about whether the court had already found equities in favor of my client Deltran. And if you go to footnote 5 on page 10 of our brief, we do say, in a later hearing, the trial court again agreed with Deltran that plaintiffs created this situation when they filed this lawsuit, and that Deltran was doing nothing wrong, but rather exercising a right the Florida legislator gave it. So that finding has already been made. I'd like to turn to the two other arguments that the appellant has raised today. The first goes to the issue of the expert testimony. So Judge Boatwright, you asked, I think, some very pertinent questions on this, and I'd like to address some of them. Number one, they never asked the court to continue the hearing or to set a new hearing as to the valuation. That seemed to happen a lot in this case, where there were problems that they now raise on appeal that they could have fixed in the trial court, and they did not. I think that is a preservation issue. Number two, both parties agreed that the trial court did not have to accept the expert testimony. And what happened during those arguments is that counsel for DTC said, we want to be able to explain to you what that other evidence is that you could accept. Can we submit proposed orders? And my brief lays all of this out, Your Honor. And they did. The judge said, absolutely, I want to hear what other evidence there is. And so what does DTC do? They submit a proposed order, and the only evidence they cite is their expert's testimony that the share is worth $560,000.
Did the trial court make any factual findings as to how they arrived
did.
at this?
Yes, and I think this is a really important point, Your Honor. No judge has to use the magic words, I find competent substantial evidence. All that they have to do is cite to that competent substantial evidence. And our trial court judge did. On page 10 and 11 of the trial court's order, she outlines in an entire page what that testimony is. And I would agree it was a little glib of her to maybe say that our expert's testimony was not clearly wrong, but then she goes on to say that the court finds that Ms. Womack, that was Deltron's expert, that her opinion is consistent with applicable legal authorities. So right there, she has found that we have satisfied our burden. And then she goes through on page 10 and lists all that evidence. What Ms. Womack said about the voting rights, about her study of public companies, comparing voting and non-voting stock, and how she valued it at 1% and then took 5% of that share for the voting rights and came up with the number she came up with. So to say that because she said, well, Ms. Womack is not clearly wrong, that there wasn't competent substantial evidence, simply because she didn't use that phrase, that is wrong. I'd like to also touch on the issue of the argument that the judge did not follow the statute related to the solvency finding. So here is what happened, and again, I think this is a preservation issue and also one of harmless error. So during the course of the proceedings, Deltron asked the trial court judge to sever the solvency finding, and it makes sense. Look, judge, go ahead first and determine value, and then we'll determine solvency, and then we can have an order that orders the payment once you find solvency. I'm not sure why, but it took the trial court judge a number of months to decide this case. And in it, what she did is she determined valuation, and then she ordered payment. At that point in time, and I don't know why, DTC should have said, filed a motion for a hearing, and asked the court to first determine solvency. Say, judge, you forgot to do something. We severed the issue of solvency. You haven't done it yet, and we need to decide that first. They didn't. They just sat back. You see that happening a lot in this case. And so instead of that, they waited to get paid. And remember, Ms. Dion received a $2.3 million payment, so she wanted her payment. So we filed an affidavit of solvency, which satisfies the statute, which shows solvency, and they never contested it. It just sat there. We then submitted payment, and Dion accepted it. And the only thing that we have is DTC, who didn't accept it, despite the finding of solvency. There is no evidence that any of these payments render them insolvent. The only testimony shows that the company is solvent even after the payments. And the only remaining payment is in a trust account and available to be paid. So on the three issues that they have raised today, the issue of statutory construction, the issue of solvency, the issue of whether or not the judge has followed the statute, and the expert testimony, all of them are arguments that fail, and really, this court should PCA this case. It does not deserve to have a written opinion. I believe that the language of the statute is clear, and that the court can simply affirm this, and we would ask that the court do so.
Well, you'd take any affirmance, I'm sure, so. Well, a question, on the Class B share, I mean, it kind of raises the judicial eyebrow a bit that it's valued so low. I mean, if I have one share of stock and I can veto anything, not anything, but a list of things the corporation can do, that's power. That's a tremendous power and I think value. So walk through again, in the little limited time you have, what evidence is there to support that value is?
Sure. So I think the
financial
evidence, again, which is on page 10 and 11 of the final judgment. Judge, the value of a share typically in a corporation is the monetary benefit you get from the share. And all of these experts admitted they'd never seen a share like this before. It was very unusual. And these were experts with decades of experience trying to figure out how to value the valuation of a share that holds no monetary benefit and a limited control right, this limited right of veto. It was troublesome. It was troublesome for everybody. And so what this expert did, and she says, is that she went to studies of public companies comparing voting and non-voting stock, and she came up with an analysis which is 1% of the total company. That 1% represents the one share, which is a $6,700,000 company value, and took the 1% of that, which is $67,000, and then took 5% of that to represent the value of the share. Your Honor, it could have been 10%. It could have been 20%. She came up with 5%. Nobody is here saying that's right or it should have been higher. And so I believe that the evidence is competent, substantial evidence, and the fact that it could have been a little higher does not make it not competent, substantial evidence.
I'll give you 45 seconds to conclude, if you'd like it.
Thank you. I have concluded. Unless there are any other questions?
We're good.
Thank you.
Thank you, Your Honors. First, I'd like to talk about the setting aside the election argument under 1436 subsection 1. Appellees discussed the supplemental authority they filed, which I think is interesting because what we see from the Florida Supreme Court is that trial courts are not allowed to ignore words to narrow statutes, and that proper statutory interpretation requires reviewing statutory provisions in the full textual context of which they are a part. And you'll notice in that case the Supreme Court considered multiple subsections when it made its decision. And it ultimately ruled that you can't add words in order to narrow a statute. And in that particular case, it was a situation about whether a creditor could come after a bank account that was owned by a husband and wife, and whether the account was made in their name or whether the account was originally made in the name. In order to get to the ruling that the trial court had, you had to add the word originally to get there.
Could I quickly ask a quick question? could you have multiple petitioning shareholders in a case? In other words, could more than one shareholder be a petitioning shareholder?
I don't know of any reason why you couldn't, Your Honor.
Okay, so you could have multiple petitioners, correct?
I would believe that you could,
Okay.
yes.
In
Your
this
Honor.
case, we have just one.
I mean, in this case, we had multiple petitioners. We had DTC and we had Ms. Dion.
Okay, so, but were they petitioning together or the petitioning separately?
I mean, it's in the same complaint.
Okay,
So
so
it's
I mean,
the same count. Mhm.
Okay.
Yeah.
Okay, 'cause I'm just, the subsection 2, where it says "other than petitioner," seems to me it has to have some kind of meaning. And that, to me at least, and maybe I'm wrong, it sounds like no one's on the same wavelength as me, but it seems to suggest that when the petitioner seeks this election, or when the petitioner proceeds, that this "other than petitioner" language must have some effect on subsection 1, excluding the petitioner from.
I don't think so, Your Honor, because the actions that we're talking about for subsection 2 refer to dismissing the dissolution count, refer to selling the shares to an entity other than the corporation, refer to settling or removing the court's power from the action. What we're talking about in section 1 is setting aside the election and reverting back to the dissolution proceedings. And I think we saw the trial court was confused by that on page 280.
So subsection 2 in your mind doesn't discuss the procedure of the election process and then potentially setting it aside?
Your Honor, I believe section 2 discusses the procedure if a petitioning shareholder, or if a shareholder were to elect and then the corporation has notice requirements and then other shareholders can elect and then they become parties. And then it talks about, well, if the petitioning shareholder wants out, right, wants to say, oh, never mind, which is what the trial court said, then they have to follow this process and the trial court can look at the equities. But the trial court thought it couldn't even get to that point. The trial court thought, oh, well, I can't.
Here's what's in my mind. The petitioning shareholder says, I want to elect here too. And you've made your election. That means you don't have to worry about the equities any longer, right? If you elect a.
I don't think the petitioning shareholder can also be an electing
Okay, well, I guess I'm confused then. What I'm saying is that the election, you've elected the path you want to go on. Whether it's equitable or not, you've elected it. I think that's what I heard Ms. Sandridge say.
I don't think that's right, and I know she cited the language in the Florida commentary that says absolute. I'll know that's not in the Model Business Corporate Act. You won't find that. It's not in the statutes. I noticed that they don't discuss the Giulietti case from Connecticut, which talks about the power to revoke is actually the court's power to revoke. And if you look at the Utah case, if you look at the trial cases that were cited below, you'll see that those all include subjects. I don't want to go over my time to finish, but
Council went
Thank
over a
you,
little
Your Honor.
bit, so we'll give you a little leeway here.
thank you. The examples in
We're
the
equitable, okay? We'll give you some time.
Thank you, Your Honor. The examples in the Utah case include, all those statutes they cited included a subject in that statute. The same thing with the trial court counsel for Deltron, for Deltron. They cited a bunch of Florida statutes. They all included subjects with the word revoke. We don't have a subject here. The word revoke can apply to court. It could apply to the electing shareholder. And I think that there's two different actions for subsection 1 and subsection 2.
All right. Well, thank you both,
Thank you.
Council. Much appreciated.